So, hello and good evening, and welcome already to the fifth session in the program Startup School of Schools. The program was created by TechHub Riga and the Investment and Development Agency of Latvia. And yeah, my name is Paul Silic, and as per usual, I'm going to be here with you during this session. And today we are going to go through, well, quite the important topics, which are the legal aspects. So yeah, as usual, if you can, please turn on your camera so that we see you. It's always easier for me and for the lecturers we have to know whom we are talking to. And yeah, if you have any questions, feel free to raise your virtual hand or to write them in the chat. And we will answer the questions after both of our lecturers have finished, unless the questions are somewhat topical at the very moment. But of course, as in the previous sessions, write them in the chat whenever you come up with them. So, as I mentioned, today we are going to be focusing on legal aspects of building and running a startup. We will look into different types of agreements and legal entities, as well as focus on intellectual property. So today we have two amazing speakers. One of them is going to be Katrīna Feldman, the legal officer at Nordigen. And our second speaker is going to be Julija Terihana, Associate and Startup Sector Group Lead at Sorainen, Latvia. So without further ado, I would love to give the virtual floor over to Katrīna. Katrīna, welcome.
Thank you, Paul. Happy to see everyone joining this amazing, lecture. Not exactly this one, maybe it will be amazing, maybe not so much. Depends on your experience. But anyways, I think this is a great opportunity to kind of see what are the things which you should probably consider when starting your operations. What are the things you might have to consider in working towards your goals. But there's a little disclaimer which I would like to give before I start my presentation. First of all, nothing of what I'm going to say today should be considered as a legal consultation. It's more of an introduction. Well, if we are looking at the theme, it's the Startup School of Schools. So in this case, I would like to say that these legal aspects are the startup of all the legal aspects, which might come under your operations. So let's go then. So today we will cover several matters, and the first of them would be choosing a suitable legal entity. So as many of you already probably know, in Latvia, we have two most popular corporate structures. So one of them would be a limited liability company, and the other one would be a joint stock company. So those will be the two biggest ones which I will cover. But before that, there are some things you should probably keep in mind. For example, if there is something you would like to know about legal entities, how they operate, what is the corporate governance of them, then first, and I would say the initial source of information to be looked at is the commercial law of the Republic of Latvia. It's not as complicated as tax law, so it should be a bit more readable. And then, of course, comes the side of the commercial register of the Republic of Latvia. So they have provided actually a really thorough guide for each type of legal entity, for each type of legal changes to be registered. And also, they have provided some draft forms of the applications that you could actually take a look and probably get your inspiration and understanding of what you should include in your own forms. And the third one is actually something new, and as I see in practice, not actually everyone a part of legal experts know this, but they have provided an information source. So this is a site also governed by the Commercial Register of the Republic of Latvia. And there you can find each and every merchant which is registered currently. And also, this can be done for free. That's first of all. And second of all, if you have the ability to log into this portal, then you can also see their corporate documents. For example, if I would suddenly forget the Articles of Association of Nordigen, I could easily go into info.ur.gov.lv and just look for Nordigen and see the Articles of Association, which are currently in place, as well as the historical versions. So that's just a thing to keep in mind. I'm telling this because this is a little tip that you could pretty much use if you know some other company which you know has their thing going for them. And if you wish to kind of see how they have formalized it, then this is one way, a cheat code, how you could get to this information. Not sure why it's not going forward. Okay, so first one, the most popular legal form of commercial activity in Latvia, which is the limited liability company form. So to establish this company, I'm not going to cover all the documents necessary, but please tell me if you are willing to know this. But the main thing that you should remember that this is a company that has its share capital either at 2,800,000 euros as the minimum, or there is this, how to say, small enterprise package where the share capital could be starting from 1 to 2,799 euros. This is an exception because usually, as we know that, you have this idea of building an enterprise and you think, oh yeah, the share capital, sure, it should be easy. But at first, we know it's not that easy to get that much money. So there is this option to build a company, but with less funds. So there are some things you should keep in mind if you are willing to go under 280. So the founders of the company will be natural persons, but tops 5. All board members of this newly founded company will be the shareholders of the same company. And there is another fun thing. Each of the shareholders of this new company, they can be a shareholder in only one other limited liability company, which has this small share capital, so to say. So it's an option to consider, but there are some things that need to be kept in mind. Also, there is a possibility to pay up the share capital in a certain period of time. So it's not always that you have to pay it all up front, but as I've heard, this will probably change at the beginning of next year. So that's just something to keep in mind, that these things might change in the future. About the shareholders, so those can be both legal persons and natural persons, but that's in case if we are talking about the share capital of 280. And the value of a share can be starting from 1 euro cent. So that's pretty easy, I guess. Also, one thing to be kept in mind that there can be different types of shares in categories. What do I mean by this? So usually when you are talking about your share capital, let's say it's the regular one. So it has all the rights and obligations which can be considered for each of the shareholders as stated by the law. But for example, if you decide that there should be different types of responsibilities, different types of options for these shareholders, then you can set categories. For example, category A could be the category which is full on, the big shareholder, nothing affected in voting and dividends and liquidation quota. But then, for example, you can decide that, okay, we are willing to introduce another category of shares, for example, B category. And we can, for example, set in our articles of association that A category shareholders, they have voting rights and they can exercise them, but B shareholders don't, and that's completely fine. So there are some instruments which are introduced and can affect the whole managing of the company, and this can be also done through shares. So speaking about the managing bodies, so usually it's the board and of course the shareholders, which are the ones that adopt all the important decisions, look for mistakes, and question the annual accounts. So these are the ones which are responsible for managing the whole company. Of course, there is a possibility to introduce a council, but this, of course, is optional for a limited liability company. And a council would be as a surveilling body of the board, so they can question the board on their decisions. Also, another matter to be considered, probably this was something which I should have started with, but as the name of the forum already tells you, it's a limited liability company. So what do we mean by this? We mean that a limited liability company, it is not responsible for the obligations of the shareholders, and the same goes the other direction. So this is somewhat one of the reasons why people tend to choose a limited liability company as their operational form. Okay, so and then we look at the joint stock company. So as you can already see, the equity capital is nowhere near as small as for a limited liability company. So a joint stock company would probably be something that might be considered at a later stage, because there is a possibility also to change the legal form after establishment. So there is this option. But one of the key milestones to kind of keep in mind is the equity capital. And also, the stock value is a bit different as in the limited liability company's case, where it was only 1 cent per share. So here it is already 10 cents. But as well, we can set different categories with different rights. And once again, voting, dividends, liquidation quota, and as well preferential stock. So here, both natural and legal persons can be shareholders. That is also a thing to be considered. And there is also this division of public joint stock companies and private joint stock companies. So what's the difference? So the public joint stock companies are the ones which you see in public stock exchange markets. So they are the ones that are looking for investments from investors publicly. So these investors later become the shareholders of this company. But in case of a private joint stock company, it's a bit different because it's not publicly available to other investors. So that's where the saying comes in. To be one, you must know one. So if you know one, then you can go try to negotiate and say, hey, I would like to become an investor. So could you kindly show me the way in? So those would be the main biggest differences in legal forms. Of course, there are other things to be kept in mind, but I believe those should be discussed when you get closer to your desired outcome, when you know what are you looking for in your company and your way of business. So, and then to the next part of our agenda, which is shareholders agreements. So this is something probably every one of us has already heard of. If not, then welcome on board. The best way how to put shareholders agreements would be to say that this is something as a safety jacket when you are going sailing. So there is a there is a possibility not to introduce shareholders agreements, and probably nothing bad would happen. But why do we do it? Because at some point, and this section will probably be more from a practical experience. This is something when you kind of decide to move further and things get more complicated, and you understand that there is something that we need to do in order to kind of understand what are we doing in certain scenarios, what is the responsibility for each of us, and how can we move forward with this this type of setup. So the main things to be put in these agreements, first of all, is a clear division of responsibilities for each of the parties. Either we are talking about co-founders or we are talking about the shareholders. So these are almost like guidelines to be kept in mind when you are entering into this agreement. And also corporate governance. So what do we understand by this? First of all, we need to remember from the previous section that articles of association is almost like the roadmap of the company. So it sets and outlines the most responsible parts of operation. So what do we mean by this? Annual reporting years, periods, sorry. Also voting rights, how is the board set up? How is the council set up if it is appointed? So these are the things which are pretty important in the course of things. So the same here, when we are speaking about corporate governance, then we need to understand what consists for voting rights, what do we understand as our governing bodies, what are their responsibilities, what are their rights, how can we change this? And in order to kind of get the whole understanding of why and how we should put this into operation, I would say that maybe in this situation, in this presentation, it would not be too efficient to kind of give specific advice on how to do it, just to mix things up, because these are the things which should be considered from case to case, from business to business, because those might change, as well as the initial shareholders might change, as well as the co-founders, their relationship might change. So this is something that you should kind of understand in the beginning, keeping in mind your end game and your goals. And then in the course of that, well, moving forward, you can introduce these things as you see fit. So the same for transfer of shares. So when will that happen? How will that happen? And who can do it? The same for investment strategies. So these are, how to say, these are opportunities to kind of model out some situations that would probably fall onto your desk at some point. I believe that would be the best way how to look at it. So you should keep in mind, what is your investor like? How does it look like? So what would they like to see in your shareholder agreement? So this is why you also would need to keep in mind your interests and your investor interests. So how and what proportions the shareholders will invest in the business, as well as how will they be transferred to the company? What part of shares will be exchanged for certain investments? So it's more of a negotiation process. And also, one thing from a business perspective to keep in mind, of course, a shareholders agreement, it looks like all fun and games most of the time, because we are all looking for investments, and that's super cool. But a friendly reminder would be to at least consider putting in something that could cover for situations when a company is not able to reach the financial goals that were set. And what do I mean by this? what is the game plan then? So we'll be able to look for additional investors. Yes, no, maybe. Should there be any type of requirements? So a situation that could probably illustrate this better, for example, if we have several shareholders and an investor becomes a minority shareholder. So they would probably be interested to kind of keep their position in the game and still be able to kind of monitor the situation and affect the adoption of certain business decisions. So probably this would be the place where this investor could step in and say, hey, okay, I'm fine with you looking for additional investors, but this investor needs to look like this and this and that. So once more, these are the things you should probably already kind of keep in your mind to understand how you can pull the levers to reach your interests when we are talking about investments. And why was I saying that it's a safety jacket when going sailing? Because at some point, everything is cool, everything is fine, we are getting investments, business is up and running, but you can never know when a dispute might strike, and these disputes might come really uncalled. So there are things you should keep in mind, that the shareholder agreement is not only for all the positive scenarios, but it's also for the negative ones. So you should set some rules. What happens when a dispute comes to your knowledge? What are the matters that should be disputed, in what jurisdiction, and in what authority? So there are several technical things that should also be considered while you are working on your shareholders agreements. Sorry, there's a part missing, but it's not missing. It will be provided by my colleague Julia. But until then, probably I should cover a part of this so-called lecture about employment. So also in the same type of way as we did the legal forms, there would be two parts you should probably take a look at. So one part would be the employment law of the Republic of Latvia. So this is something that you should get yourself acquainted with, either as an employee, if you are, and afterwards as an employer, because these things, which actually are quite funny, usually they do not look super complicated or super complex, because we all think that employment, it's what we do every day, most of us. But actually, the disputes which come out of employment relationship are the ones which are usually very lengthy, very hard, and very pricey. So these are the things which should never be treated lightly. From my experience, I can say that employment matters are the ones which are in the back of a startup, because usually you are more focused on business endeavors, you're more focused on growth. Of course, at some point you are trying to think about your potential employees, but there are a bunch of things that you should remember while we are on this topic. So the first one was the law, and the second source of information that is pretty good sometimes is the State Labor Inspectorate of the Republic of Latvia. So they're actually pretty open to giving consultations. So if you have a question, you can easily call them and ask for some advice. And the rule of thumb, which should be applied to everything employment related, is that anything that decreases the well-being of the employee should be very carefully considered, twice reviewed, and revisited at least 3 times. This is no joke. It seems really, really tough, but it's not that hard once you get to know how it works. And why is that? Because the power dynamic in employment relationship is switched. So usually we would say that all the other legal relationships are more or less sometimes equal. Sometimes, on the other hand, one party is in a better position. So in this case, we would intuitively think that the employer is the strongest party here. But I'm sorry to kind of crash the party and say that no, the employee is the strongest party. So this is why, once again, employment matters are not to be treated lightly. Sorry. So one of the things from a practical perspective, which in our business have came up more than once, is while doing business, we are trying to gain services from certain specialists. And at some point, you start to question yourself and ask, is this an employment agreement or is this a supplier's agreement? What do I mean by this? For example, you need, I don't know, a UX designer for your homepage, for example. And you know that there are certain things you would like to achieve during this cooperation. But you also know that they will work on their own computer. Very nice. But at the same time, you will be paying them, for example, monthly. So now the question arises, what is this? So to try and split these two things apart, this table should probably try and introduce you to the checkpoints and check marks to see whether it's an employment agreement or it's a supplier's agreement. Once more, I'm not looking at tax matters right now, because that is something that also should be kept in mind. But just from the legal perspective, to kind of understand where are we going with this, these are the main aspects. So for an employment agreement, the whole work process is prioritized. On the contrary, the suppliers agreements, they look more on the result of the work. So for example, if it was an employee, then I would say, okay, so he's an UX designer. He's just gonna work, make our UX lives better, not to set any specific goals just yet. So those will be in the work process. But in a supplier's agreement, we would say, hey, dear UX designer, we would like to see this and that until that and that date on our homepage. Can we do it? So we are focusing on the result of the work, and the payment will also be dependent on the result of the work. So for the employment agreement, if I was an employer, I would ensure that the employee has all the necessary tools, devices, as well as instructions to commence this work. But the supplier, they are completely free to do what they need on their own, with their own tools, with their own ideas and own planning. So that's a distinction that probably gives a clearer understanding of which one is which. In case of an employment agreement, it's a personal agreement. So what I mean by this is that the person which we are in an employment agreement, that we have concluded an employment agreement with, this is the person that will do the work. Exactly this person. When in a supplier's agreement, it could be a natural person, it could be a legal person. And if it is explicitly agreed in the supplier's agreement, we may attract other suppliers to this agreement to provide the work. In case of an employment agreement, of course, there should be an exact workplace and working hours indicated. In a supplier's agreement, well, this might be and it might not be. So usually we would consider that the working hours and the workplace it's up to the supplier. So they can organize their own work, they can manage it as they would like. But sometimes, depending on the work to be done, for example, if it would be decorating a venue, then probably there the work or the working hours and place would be limited because of the type of work that should be commenced. So this probably won't be the most distinguishing argument, but still, this is something to keep in mind. And in case of an employment agreement, all the social guarantees as well as safety requirements, they must be ensured. While on the supplier's agreement, the supplier is the one which is responsible for time organization as well as their social guarantees, depending on their structure. So, I mean, legal form. So if they would be a limited liability company, they would have one way of guaranteeing all these social guarantees. If there would be an individual merchant, then they would probably have a completely different way of organizing this. So these would be the biggest differences in employment agreements and supplier agreements. So another fun thing to keep in mind are workplace policies. I've heard from some startups that they have kind of checked out on the same issue. At some point, they understand, oh, we are running so fast, we are doing our business, we're growing, everything's great. And then at some point, they have a setback, which looks like, hey, we already had to introduce this and that in our company. Hey, there's a check coming in, and they will look for this and this and this. Do we have this? And then the answer is no, we don't. So to save you from such situations in employment relationship and anything related to employment, these should be the main things to be kept in mind when we are talking about workplace policies. So the first thing you should kind of sketch in your minds is a pyramid. So at the top would be employment law, because employment law regulates employment relationships for anyone, for any person in the jurisdiction, anyone. Then come workplace rules, which are something a bit more specific than the employment law, because the workplace rules are for all of the employees in the same company. And of course, then comes the employment agreement, which is personal, because as I already mentioned before, it's a personal agreement. So why is this important? Because at some point, the workplace rules and the employment agreement, they might switch. What do I mean by this? I will get to that, but for the mandatory perspective, health checks should be one of the first things that you should keep in mind. So there are some specific rules and regulations which are outlining specific conditions of work that might affect an employee's health. And for example, if your business or work includes such positions where an employee's health might be affected, then it is an obligation for the employer to send their employee to a mandatory health check. So first of all, this is to know if the person is actually able to perform the work. And this is also paid by the employer. There is a case where this should not be paid by the employer, and it's in case when in the initial interview, the potential candidate says, yeah, sure, I can do this work. I'm super healthy, everything is fine. And when you go to the mandatory health check, the doctor just writes down, sorry, this person is not able to perform the work due to health conditions. So Then we would consider that even if it was the employer's obligation to pay for it, the candidate was giving false information. So this gives the right to the employer to charge the costs to the employee. And then comes the moment for the workplace rules. So this is something that is mandatory starting from 10 employees. And this is the place where the workplace rules might be switched to employment agreement. Why? Because the employment agreement for the first 10 people might kind of explain all the common rules for working time, leaves, holidays, and everything necessary for organizing your employment relationship with the employee. But starting from 10 employees, as the bunch gets bigger, there should be some things which should be established for all of them. And it's a lot easier to introduce these changes just by making these amendments to the workplace rules instead of changing each and every employment agreement. So it's just more effective. What can be laid out in these workplace rules? So I'd say everything, starting from working time, leaves, breaks, holidays, anything related to reporting, anything related to workplace behavior, code of conduct, anything. So the law provides the main guidelines, and anything which is not worse for the employee, feel free and just put it in the workplace rules. And also mandatory is workplace safety. This is something that should not be tread lightly due to the reason that sometimes when employees are feeling a bit sad that the employment relationship for some reason has been ended, they have a tendency to bring this to the labor inspectorate, and they are very keen to come on site and check if your workplace safety documents are on top of their game. So this is something that you should always remember, that there are certain workplace safety policies and procedures that need to be in place. But there's a good side to this. There are specific companies, at least here in Latvia, which provide outsourced services, and they have specialists that come to your workplace, they do the audit, they check your place, they check your paperwork, they understand what are your needs and necessities. They draft all the documents, and all you have to do is just introduce them to the employees. So this is something that can be resolved by outsourcing. And optional things, as I already mentioned, that anything that is not in conflict with the laws and regulations can be introduced as a workplace policy. Also, something that I forgot to mention about the shareholders agreements, but is also applicable here. And this is something that came also from our founders, which were happy to share about their experience in these things. They've explained that at the beginning, either you are, for example, making your workplace policies or shareholders agreements, take it as a chance to try something. Well, with workplace policies, a bit less, stick to the regulation of the law at least. But at the shareholders agreements case, try it out, see what fits. And when you get to the investment rounds, as our board member, Roland Smester said, then bad corporate governance and a serious due diligence from the investors' side equals free advice. So by doing so, you can actually get to check out some certain things which the investors see as a bit sketchy. They see a bit unstable. They see unfit for your business. And that is your opportunity to kind of take this redline the issue and turn it into an opportunity to fix up your thing and make something better. So the same goes for workplace policies. And then the same also about benefits and bonuses in employment relationship. So I think I mentioned this already a few times, but the law states minimum requirements. But in case something is more beneficial to the employee, you are more than welcome to enforce it. We all know that currently the employment market, so to say, is very challenging because people already are used to working from home. They are somewhat used to flexibility. So I believe that when you are putting yourself into a position of an employer, you need to try and kind of think of new monetary or non-monetary forms that could be beneficial to the employee. So as well as all these monetary and non-monetary forms of benefits and bonuses, things that you should keep in mind that, first of all, there is this law requirement, but also there are some tax matters which should be kept in mind. But as this is something that I will not exactly cover at this this moment, then it should be remembered that there are some benefits and bonuses that might trigger some tax benefits as well. So probably the most popular ones in the section of benefits and bonuses would be insurance, extra leave days, for example, on your birthday. I know that some companies also introduce, how is it called? Mental health day. Also, there could be some interesting ways how to, for example, report your sick days. One opportunity that we have kind of discussed is to provide that, for example, for the first 5 days when you are sick, you don't need to bring your doctor's note. So for 5 days, you can just chill, take your time, sit at home, take care of yourself. So easing up the stress for the doctor's appointment, but as well, not to take things super easy, as we know that people are opportunistic and they like to take every chance they have. We have also decided that these 5 days can be used up in a year. So you are giving something, but there are some certain conditions to be followed. So this is a way how to kind of play with the whole benefit and bonus thing. Also, of course, flexible working time, but the things which I could say from a practical perspective is that each of these benefits and bonuses that also might come out from due diligence procedure outcomes, it's not always super easy as it is fun to implement them. Because we might see something that is super, super cool, and we know that this would be something that all the employees would like. But you always need to kind of keep in mind that there is a legal framework where you need to fit in this benefit or bonus. So that probably would be the most challenging part of this. So what could trigger changes in the benefits and bonus package? First of all, maybe we should change those 3 dots in a different kind of order. And the first one would be employees and their satisfaction level. But as we are business oriented and we like to see our investors happy, then I would say that the biggest impact would still be from the investors' view on work policies. So this will be something you will see after a due diligence has been done. During a due diligence, they will see all your documents, and probably if they are deciding to invest, it might also happen that they would say, hey, this is cool, but I would like to introduce also this and that, as well as a merger bonus. So this is something we are currently experiencing. There was a pretty big deal in our market. One great company, Go Cardless, acquired Nordigan, and now as a merger bonus, we are adopting their holiday policies. So these things can change from different perspectives. And yeah, of course, changes in the legal perspective, that's something that will be there, and you just need to follow up and see if you are on top of it. So I think, yeah, I have covered all of my topics. And I probably would say that the next really interesting topic, which also is to be kept in mind when we are talking about shareholder agreements, is intellectual property. So, Julia, feel free to take it away. But I see that there in the chat there are several questions. But if you don't mind, I would be glad to answer them after Julia's speech. Would that be okay with you?
It should be okay, and it seems it's more like a discussion. You will have now the time to actually read through it, what's been written there, what's been commented on. So yeah,
Okay.
should give you ample enough time to do that. Okay, as you already mentioned, then we move on to our next speaker, Julia Terjuhana. Julia, are you ready to take over?
Yes, sure. Hello, everybody, and thank you for inviting me. And I will kindly ask Paul to switch on the presentation.
Yes, doing it currently as we speak, looking for, give me a moment, sorry. Not used to be being the one who shares the presentations. Okay, here we go. Do you see my screen?
Yes. In working mode so far.
Yes, and it
now
should be
it's
full screen now.
Thank you.
Okay.
Yes, thank you again. My name is Julia Terjuhana. I'm a lawyer, and I work with the field of technology, telecoms, and media, and deal with intellectual property, among other things, on my daily basis. And today's presentation will be about what is intellectual property, how can we protect it, and what would be your home task after hearing this presentation to check what kind of intellectual property already is in your possession. And we can continue with the next slide. And here briefly, we can take a look what can be intellectual property. This is something which is the result of creative work. You probably have heard of trademarks. This is one of the most popular type of intellectual property. Also copyrights. Maybe a less popular thing is industrial design. Also patents are very popular. And oftentimes businesses want to patent something without knowing that not all things can be patented. And today we'll try to distinguish among all these types and get clear what can be registered and what cannot. Also, our business assets, all various types of assets that we have, also computer code, different documents which have been created by human beings as a result of creative work. Even though they are not works of art, they are still protected by copyrights. And also different outcomes of research and development in different stages of it are protected by copyrights. And if we take a look at the next slide, then you will see various types of intellectual property, and in brackets you will see that whether they are registerable or not. There are under each section there are some of examples, and we will go through all of them, at least all of those categories. First of these all are trademarks. And first thing that comes to our mind is the name of our company or the name of our product. And we may have various products, and each of them can have a separate name. We can register a trademark just as wording without any visual appearance, without any visual representation. But we also can register this visual logo. Many of them you can see in this example in the top left corner. They can be black and white, they can be colorful, they also can be dynamic. This is a new feature that can be registered. For example, you have created this unique logo which moves in different ways, and at the end it creates like one logo. For example, let's say Adidas, well, one by one, brick by brick, it falls one by one, and at the end it creates the whole, this triangle logo. It can be registered as a dynamic logo. Also, a sound can be registered as a trademark. This is not very common, but maybe the most popular, which you have heard of, is this Metro-Goldwyn-Mayer lion's roar, which you can hear at the beginning of movies. Then this such thing can be registered. This is about trademarks. In the next slide, which please don't move yet, but in the next slide we can later discuss in what different ways we can register our trademark. There are also patents, and oftentimes clients are mistaken that each and every new product can be patented. We would like to protect our new product by all means possible, and we have heard that there is such type of protection as patenting, and they oftentimes come to us and say that, please, we would like to patent our product. But first of all, to be able to patent something, it needs to be very novel, like unique and new, solving new problem. You cannot patent something which is already in the market. Very similar things, oftentimes services, online services, and mobile applications are very often similar to something already existing in the world in other countries. And this is completely normal practice, that we create something regionally specific based on the same operating principles we have seen somewhere else in the world. Therefore, lack of novelty may actually be one of the most common criteria why something cannot be patented. Also, the technology needs to meet this industrial applicability. This means that the product needs to solve some kind of problem, and not all IT solutions or applications or digital tools actually solve some kind of industrial problem. Therefore, for example, for code itself, oftentimes the programmers or companies who actually own this research and development base, they would like to register this code patent. It is possible, yes, but very often we combine code from unique pieces created actually by programmers and pieces of code which are already available somewhere in the internet or already have been created by other people. And therefore, it can be a struggle to distinguish whether this whole code is unique. And if it is not, then it is irrespective of the patentability, it is protected by copyright. This is a good thing. To determine whether your code or your product is patentable, then you need to turn to these patent specialists. These are not typical lawyers from the big law firms. Usually, at least in Latvia, these are special offices of patent specialists where specifically trained professionals who have this qualification of patent specialists and also have qualification of engineer at some kind of engineering area, for example, in computer science or in building construction, if we want to register something from a construction area, or in chemistry, in medicine. They need this additional qualification in order to distinguish and determine whether this product is unique in their specific field. Trade secrets are non-registerable, and trade secrets are protected. Now we have this trade secret law, and they are protected by law, and also they can be protected by internal documentation, and they can be protected by non-disclosure agreements, by confidentiality clauses, which we include in our agreements documents, internal policies. Also, designs can be registerable. One of the examples is here in below right corner. This is this shaving device, and this visual appearance is the main feature that can be registered, not the functionality, and these things which are inside in this device, but only the visual appearance. And the same can apply to mobile phones, to different digital gadgets and things like that. And copyrights come in different shapes and kinds. It can be text, it can be software, music, images, instruction manuals, everything like this. Please, let's move to the next slide. Speaking of these trade secrets and different business assets that we can have, this is just a good list, I think, for you to take a look at what different kind of documents may have copyrights in them, and to think that actually we need and should protect them. And typically, copyrights, for example, are protected in shareholder agreements, as Katrina mentioned. Also, if you have employees, you include this intellectual property clause in employment agreements. If you have forgotten to include such a clause, then law works for you. And depending on the country, the rules may vary. In Latvia, if you hire a programmer and you forget to write in your agreement what will happen with copyrights, then law says that in such a scenario, the employer owns the copyright to the work created by programmers hired by them. But if a regular employee who is not a programmer creates a work and his relationship with the employer is not regulated, then copyright is owned by this employee. On one hand, nothing dramatic will happen, but we see from a legal due diligence work that we have when future investors are trying to find the best companies to invest in. They typically conduct a legal due diligence, and then we mark those red flags. And this is one of the common cases that trade secrets or copyrights are not regulated anywhere. And if we think about our products, these little things are all around us, starting from company name. And now think about who has created the logo of your company. Maybe a friend of yours, maybe you have created it by an automated tool somewhere online. And what is written there in those terms and conditions, or whether or not your friend or service provider who works on case-by-case basis has actually any written agreement with you. Maybe this is a good time to have at least a one-pager for this matter that you can already sign post factum, so to say, that yes, this and that person has created a logotype for this startup, and all the copyrights now are transferred to the company. And the same applies to all those programming assignments and the large amount of work done by those who are starting the company together by their own forces, meaning that at the beginning, when things are happening very fast, we forget to regulate the important things. And shareholder agreement can be the good point when to regulate what has been done, what is now present, and how do we regulate what we have now. And it is important to transfer this copyright from those individuals to the newly established company, so that we have this intellectual property value as a valuable asset for this company, which can be already evaluated and seen as an advantage for the company itself. Let's move forward. I think I mentioned almost all of these, and we can go ahead. Speaking of trademark registration, there are 3 possible routes. We can register trademark locally if we just plan to operate in one country, or it would be a good beginning, at least. This in Latvia, it is done by applying to Latvian Patent Office. Don't be confused by the name. It works with all kinds of trademarks, patents, and also different type of registrations for medicines and different types of intellectual property. There is also EU registration. There is this unified procedure how you can register if you plan to expand to other EU countries. It would be a good way for you. And it is typically done online, also can be done by post. You submit an application, and then your application is being reviewed, and you are being granted this registration. Also, think about who submits the registration. If you don't have a company yet at this stage, but you already want to protect your trademark, for example, then it can be fine. And later on, when you have a registered company, then you can change the ownership. This is normal procedure to maintain. There is also this WIPO international registration. There is an example in the left corner. It means that you submit a registration somewhere locally in the world, for example, starting with Latvia, and then you realize that, oh, I need also other countries, for example, United States or Canada or China or Russia or wherever. Okay, Russia was a bad example, but typically also this neighboring area, which might not be also the European Union, can be covered by this registration. You submit your local registration, you are being registered, you have this trademark protected here, and then you submit this WIPO application and designate, so to say, your trademark protection to another region in the world. And you don't have to travel anywhere. You do it by submitting application locally, here in Latvia as an example. Or if you are from other country, then you go to your local office and submit it there. Typically, it's not a very fast process. For example, WIPO process takes from 12 to 18 months. And it also includes the procedure of objection. When your mark is being received, then it's being reviewed and published in the official gazette for others to consider whether this future trademark will or will not breach their existing registered rights. And this is the risky period when other companies can submit their claims and objections against your mark, and this official institution consider them and think whether your mark is actually registrable or not. And as the result, they may or may not register your trademark. Therefore, before any trademark registration, it is very advisable to conduct trademark search. This is a process typically conducted by a legal specialist when they open all the necessary trademark databases, the local ones, European ones, also these worldwide, and check whether there are marks which are similar or identical. And the rules for the trademarks are that trademarks work for specific regions, meaning that if I want to register, for example, a trademark for India, then I check this Indian trademark register and also WIPO trademark register. And I check for specific class of goods or services. If I provide, for example, a mobile app for sports, some kind of fitness activities, then I check mobile apps class, and I check fitness sports activities, things like that. And only for these ones, for example, my name or my surname could serve as my trademark, and then other company would be able to register the same mark in India, the same containing my name, but for different kind of activity, for example, for coal mining or for, I don't know, chemical production, and it wouldn't be a problem. It is possible, and it is a normal way of doing things, but if there is the same mark or confusingly similar mark, in the same location, in the same class, then this is a problem. And it is better for you to find out about this problem and be able to whether to change your trademark, the wording of it, and also it's possible to do search for visual marks. It works similar to Google image search. Then the database just show you the most similar results. Then maybe it can be the right time for you to change your logo, to add some features or remove something or add colors to increase the registrability. Yes, I think that's it in short about trademarks. About research and development and intellectual property covered by it, some of the startups definitely conduct research and development themselves. This is also a normal routine, and all the prototypes and products on the way are protected. And as the result, oftentimes it can be a patent. I already explained a little bit about patent. And the same way of registering works for patents. The same three offices work for patents, and we can register patent locally, also in Europe. We have this European Patent Office and WIPO. Before registering a patent, it is necessary to conduct this patent search. And this is more complex procedure. When submitting a patent, you need to describe it in very much detail. If it is based on code, then you really need to provide the code. If it is a machine, then you need to provide visually all the descriptions and all the sketches and descriptions of each part and how it functions. If it is a chemical substance, then you need to provide formulas and so on. It also is a quite lengthy process. It also contains this process of objection, but as the result, you have this strong protection. And in both cases, for trademarks and for patents, this period of protection is defined in time, and it is not eternal. It is not forever. For trademarks, for example, It is 10 years, and you can extend this period step by step. After 10 years, by another 10 years, and then by another 10 years. And there is a limited time, number of times how many extensions you can receive. And then again, for example, for patents, technology becomes, so to say, available for anyone to use for business. Yeah, this is the end when the protection ends. Let's move forward. Yes, and here we are coming closer to our, so to say, homework. Let's go through this list of myths and mistakes. I already have mentioned some of them. And one of the most common mistakes is avoiding IP topic at all and thinking that you don't have any intellectual property to protect, or believing that nothing is going to happen. It can be the case when your competitors see your product and steals the idea. Ideas themselves are not patentable or protected by any trademarks, but still, based on those ideas, products can be created or similar trademarks can be used. And then there is a possibility, of course, to submit a claim in court or send them notices to cease and desist, but it is much more, the chances of success are much more higher than when your product has these registered trademarks or protected copyright actually in written form. Doing things yourself can be also risky because there are so many details in intellectual property rights protection that can be also just known by legal professionals. And of course, doing things yourself is a good start. Also, initial trademark search when you are creating and, for example, looking for a best logo for your product, at least do some search yourself. This is a good start. But on the other hand, we just had a similar example from our clients that the client did the initial search and said that I didn't find anything very similar, but maybe you can look. And we actually found a very risky trademark, which was already related to some appeal, meaning that there was a company, there still is a company, and there are many of them who very frequently monitor these official gazettes when trademarks are being published for registration. And if they see anything similar, they are very proactive and they don't want any competitors in their market. And they already submit claims. So lack of attention or proactivity from your side may end in some legal consequences too. Failing to create original trademark, yes, is meaning taking every other trademark from this automated trademark creator. They may be original, it is true, but sometimes I already see from search results when I am conducting searches myself that there are so many similar trademarks, especially if there are some kind of letter in a square or letter in a circle, in black and white especially. This is very common, that because it's cheap, it's a good way to start business, doing things by automated means available for free. This is a good start, but be aware that you need to add some creativity to be original. Ignoring IP is one thing. Being very active, not active, maybe not the right word, but willing to patent or register trademark everywhere, this is also not a good strategy. You need to focus on those markets which you are really willing to address or expand to. also take into consideration that registration process is quite also not only time consuming, but also resources consuming. This trademark search costs a certain amount, then registration fees cost. And by the end of registration, there is another cost for finalizing the registration. And if you would like to register everywhere in the world, this would cost you a fortune, believe me. And therefore, choose wisely, but also consider the good ways for expansion. For example, if you register through this WIPO, then you actually, through your local registration office, you can reach any part of the world. I think this is very practical thing to do. What else? Let's move forward, I think. And what are other things to consider? Looking at your product, you by the end of this conversation, you already will have this checklist. I think this is maybe the presentation itself is quite lengthy, but I believe that you will have this checklist to consider and think what kind of IP I already own by my company, and whether the rights are moved from myself to the company or from those people previously involved or in creating intellectual property to the company. What is the most valuable, and whether it is registrable, and what will be the product and how we are going to commercialize it, and whether the IP owned by me, by my company, is closely related to this commercialization, whether the product or the trademark is easy to reproduce, and what is this lifetime for the technology I produce, and whether I plan to change my logo, for example, in the coming years. If I do, then there is no use in registering it for a very short period. Maybe this is the right time for me to decide on this one very, very good logo, which will serve me for longer years. And then after these years, I already will be able to register another logo if I would like to, or if my logo changes. Also, this could be a logo that is easy to combine with different words, or to adjust the shape, or putting in other as other part of other logo, and then at least a part of this future logo will be already protected as this old logo. You need to take a look on the markets, on the regions where you want to enter, and also whether you are willing or not to actually spend money on it. Speaking of registration costs for patents, costs will be higher, this is for sure. But before actually becoming scared of any fees, any legal fees especially, registration fees will be the same, because these are defined by these registration offices locally or internationally. But legally, fees are very different, and for larger offices like Sorainen, these will be one fees. For smaller individual practitioners, these will be different fees. And for you, my suggestion is address your email and ask, I would like to register my trademark, please, could you provide your fees? And then you will maybe have some 3 or 5 offers, and it will be easier for you to choose, depending on costs, depending on the personal contact which you receive, and depending on the communication style. Maybe you prefer a little bit higher costs, but easily responding or easygoing lawyer on the other side, which is proactive, willing to help. This is very individual thing, just like finding your best doctor, finding your best lawyer is quite the same thing. Okay, there are some, I think, some 2 slides left probably. Where to start? I believe that we already discussed all these things, and we can move forward. Yes. Speaking about what kind of IP you own, create this list, check whether you have any inventions, and this is completely fine if you don't. If you don't have inventions and you don't have patents, this is completely fine. If you don't have any tangible objects, most likely you will not have any designs, but you will definitely have copyrights. This is for sure. If anyone creates code for you, this is certain that copyrights will be in place. When you are using anything protected by copyrights in your product and taking copyrighted products from publicly available sources for free, please be careful and read terms and conditions. Even those open licenses, open access licenses, oftentimes are limited. Some of them allow you to use their products, for example, pictures, for commercial purposes, but not all of them. In some licenses, it is explicitly stated that commercial use is not allowed. And this is another way how you can get in trouble if you use copyrighted objects, sounds, visuals in your product. Therefore, you want your product to be as copyright dispute-free as it is possible. The same for trademarks. Make sure whether your trademark is already free from claims from that person who has created that mark, whether it is an outsourced company or it is a friend of yours. Just make sure that he or she or they don't have any claims, meaning that you have to have it in written format. Or at least when the time comes, you will need to make this smaller or bigger contract in place. Take a look what is the most valuable for your business, and consider what you need to protect, whether to do it now or you will do it in the future, and analyze your products and what unique elements they have. If they provide these technical improvements to similar products in the market, then it could mean that they have this inventive step and can be patented. But not always it is true. Sometimes they just, for example, if it is a platform for selling something, most likely this will not solve a unique problem, because platforms for different needs are everywhere. But if it is a unique digital tool, for example, for measuring something or for detecting something, then it could be the case. And be ready to act if someone else is using your trademark as a target. Especially if you enter the US market, it is very active. There are very, so to say, there are many IP predators, we can say. There are many individuals and companies who are targeting those who are entering the market. They already are filing claims as soon as they see the company with some kind of similar product, similar name, or similar logo entering the market. They are ready to file the claims. So just be ready, find a lawyer, be aware that such thing can happen. Yeah, and I think then there is one more slide for you. Last but not the least important is that not only you as a company owner or one of the partners of the company need to be aware of the intellectual property owned by company and its protection, but also please inform the employees, make them aware that they work with important things, important values, important objects of intellectual property, that they are creating something valuable for the company. Provide the policies, include information in their employment contract, so that you are protected and also they are aware that things they work with are important. It can be just plain text, something related to your strategy. It can be visual material. It can be something related to inventions or general business strategy. All these things are important, and the person who is aware will be most likely more cautious with what she or he is doing rather than one who isn't. I think this helped. I see that there are already some questions. I also remember that in the questions sent previously, there was a question about the GDPR. But first, I will let Katrina answer her questions, and then I will read mine and continue with them. Thank you.
Sure. So I would like to say thank you for this presentation, because I think it was amazing. It was very, very thorough. So thank you, Julia, for that. Always a pleasure to see a great colleague at work. Also, about the questions that were provided in the chat, Paul's was right. It was more of a discussion, but to some questions which were provided, I gave some private answers, and there were some interesting discussions there as well. But all in the scope of the previously discussed. Then if we would cover the questions that were given before this presentation, then let's start with some of them. So one of the questions we got is about jurisdictions. So is there much change in comparison with jurisdiction in Estonia, Nordic countries when it comes to startup law and law prevailing over the contract? So sometimes I hate this answer as a lawyer, because people expect that lawyers can give good answers to their questions, but sometimes the profession, it is what it is, and we have to say that unfortunately it is not easy to provide an exact answer to these two questions, because everything depends, first of all, on the subject of the contract, the product at question, the business type. So I would say if you would have a more specific kind of idea, what are you looking for, then it would be easier to kind of evaluate those both jurisdictions. Funny enough, we have the same question in our business right now when we are discussing sales agreements, because they, this is actually an interesting practical insight. At the beginning of our business, you know, you are really willing to get your client to buy your product. So you just stick to whatever they say. For example, your client would say, yeah, let's do, I don't know, Norwegian jurisdiction or French jurisdiction, whatever. And you're in Latvia, just an example. And you say, yeah, sure, let's go. Let's just do it. And then when it comes to a merger stage, all these questions seems to rise up. And then we actually had the same question. So we have our clients which are currently still offering jurisdictions of Lithuania, Estonia, which are pretty near, same Baltic region. And the question which we were asking is it fine to accept these jurisdictions in terms of providing our service, which is a regulated payment service? And the same for the law prevailing over the contract and and all the other things. And the answer we received, and actually it's a really good advice when you come to think of it. For example, if you would apply this specific jurisdiction, would it be as easy to terminate the agreement as if it was in under your jurisdiction? So if you don't have a specific answer, one way how you can try and find out, which is super ineffective, is you can just try and find out by their laws and regulations, but it will be very time consuming. Probably you would miss something. So it's not too efficient. The other way is to find a lawyer in this jurisdiction and ask them, what are the standard clauses for example, terminating agreements? Same for startup laws, but actually for startups, it could be a bit easier because I believe each European country is quite interested into bringing more startup action into their business playground. So I believe they would provide some more information on that. But on the regular laws and regulations, I would say either it's those two options, or the third one, you just put your foot on the ground and say, this is a non-negotiable, and we are sticking to one specific jurisdiction. So yeah, I would say probably you should try and scope your question, find the angle of it, and then probably it would be easier to kind of find out which of the sections is better, and also in what way. So are you looking for tax benefits? Are you looking for reporting benefits? Are you looking for obligations? Just an example for anti-money laundering. So in Latvia, account information service providers are a subject of anti-money laundering. But in Lithuania, they aren't. So when you have something smaller to pick at, it's easier to find the differences. Then there was a question about silent shareholders in the company, the ones that came along initially, but they are not either active or critical for the company. Is there some kind of shareholder status that should better be put in the shareholder agreement, indicating that whenever an investing VC, venture capital would like to buy someone out to acquire more shares without diluting active and vital for the company shareholders, they would be the first to be considering to sell their shares if all the other shareholders agree. So when we are speaking about such, I would say, uneasy situations, then my first advice would be when you are thinking about your shareholders agreement, make sure that your articles of association already have some grounds, for example, for voting requirements. So is it a 50-50 share? What matters go under 50-50 shares? What cases do you need a quorum for? So these would be the first limitations to keep in mind that could probably help you settle such silent shareholder cases. Of course, then depending on your business, depending on your plans, depending on your on the interest of the investor, these shareholder agreements might change, and there would be certain scenarios implemented in order to describe a situation where the so-called silent shareholders are in less favorable positions. So another way how we could also affect their, possibilities to exist in the company is by dividends. For example, you decide not to pay dividends. So you don't pay. A shareholder suddenly starts to feel intimidated. Like, what's happening? Where are my dividends? Another way how you could also prevent this, also by amending your articles of association, is by introducing share categories, which I already mentioned before. So these would be some simple ways how to probably target this. But once more, when we are dealing with shareholders agreements, my best advice, best for time, time, money, nerves, is find someone who specializes in this. Find a lawyer who is super specialized in shareholders agreements, in these relationships, because it can get messy. And especially if you're trying to put someone out of the picture, it for sure will get messy. So that would be my best advice. Then there is a question about deadlock resolutions. What types are there? And when, yeah, that's when shareholders cannot decide on something. So what do we understand when we are speaking about deadlock resolution? So as the word says, it's a deadlock. So there is a situation where some decisions are stuck because there is no decision to be made. I would say there is a decision, but there is no possible way how to do it. Once more, either it's because the voting rights have been set up in such a way. For example, if there are only two shareholders, one says yes, one says no, then there is nothing to resolve there. So again, there is a possibility to split the shares. So there is a different balance of them. There is a possibility to introduce a new shareholder. So that's something along the way you should think about. But what happens in a deadlock? First of all, you look at the Articles of Association, which establish the rights of voting. So those are the outlines. And then once more, in the shareholders agreement, there should be cases which you have described what happens when there is a deadlock situation. So what could be possible ways to resolve this? So one would be, you could probably use negotiation strategy. So what does this mean? You would say, okay, so if we are in a situation where we cannot decide on anything, it's a deadlock, we have to negotiate. So you come together, you negotiate until you negotiate something. If not, then another option is to put this thing to court. Pricey, lengthy, not too good. We want a better solution. Once again, we try to consider other options. Then there could be a chairman deadlock clause. This means that, for example, if there is a case where we cannot settle a decision, then we have the ability to elect one of the shareholders as the chairman, and, for example, appoint him a heavier vote. So whatever he says, that's what we're doing. Of course, there is this opportunity to say, okay, if we cannot decide on this, then let's just liquidate the whole company. So there is this liquidation deadlock clause. So there is a bunch of clauses you can actually introduce. It mostly depends on your approach, which you are willing to take, and of course, the business model and the investor, which you are looking for, your dream investor. So probably my advice would be, find out what's in store in the market. Look for some more experienced startups which already have their shareholders agreement. Most likely they won't show it to you. That's fine. But you can at least, check the room temperature, ask them, hey, how do you think? How would this situation be better resolved? So what is your take on deadlocks? Just go ahead, feel free, discuss. That could probably lead you to a better answer. Okay. Not sure if I've found all my questions, but while I'm looking for them, maybe Julia could kick in and take.
I think there is a quick question regarding what you were just talking about, Vlad. What is the usual practice to include into the shareholders agreement to settle deadlock situation? Just in 2 words, very quickly, as we are also running out of time.
No, sorry. Not to say that I have seen so much of those, but I would say one that comes to mind is the arbitrary, where you take it to court, and liquidation clause. Those are the ones which just kind of come to my mind the quickest. So both are quite radical. So if you can decide, just liquidate a company, so it makes people decide things. And the arbitrary one, the same. So if you are willing to stand up for yourself, then sure, why not? I hope I answered the question.
Yeah, thank you.
Okay, I will move to the last question about NFTs and using photos of famous people for NFTs or photos of landmarks. This is quite a common question. We have already analyzed that internally with our clients. And actually, if you take photos of famous people and they consent, this is completely fine. But if you don't ask for their permission, then it is considered use of personal image for commercial purpose, and this is protected, and this cannot be done without person's consent. Then these people could just submit a claim or come to you and ask, hey, please stop using my image for this purpose. This is illegal. You cannot do that. If you use images of dead people, deceased people, even if they are located somewhere in the world, for Latvia, that would be more or less fine. There could be cases if such use negatively impacts those who are the now living relatives of them. This would be the case when they could object. But this, I would say, this is not a common scenario. But for other countries abroad, for example, for the US, if you use pictures of some, I don't know, dead movie stars, then in some states of the United States of America, there are rules that those who inherit all the goods from the deceased member of family can actually also have this right to use the image, for example, for remaining 70 years, meaning that if you use their photo, it would mean that you are doing this illegally, or you will need to pay the relatives for such use. And regarding landmarks, my guess would be that the old monuments, some kind of buildings from historical era where their architects and owners of initial copyright are no longer alive, this shouldn't be a problem. If only if you are trying to photograph a private property, then could be some privacy issues. But if you are trying to photograph and then use for commercial purpose something what is newly built by some famous architect and then use for commercial purpose, I would also this consider a risky case, because use of such pictures for informative purpose is explicitly allowed by copyright law, but for commercial purposes by other persons, I would say no. There is addition to this question. It is clear about photo. What's about work of artworks? Artworks of the same pictures, the same persons, meaning those who are other living artists. Glasna, yes. But would it be your own pieces of art or there? Yes. If it is yours, this is no problem. If it is your image, if it is a work of art created by yourself, it shouldn't be a problem. Yes, and if we move to this GDPR question, which was sent in previously, then yes, EU, United States, and United Kingdom differs. Previously, UK was the same as the EU, but now it also may have some differences. Basically, it is the same, but differences can be there. And the United States is completely different, not completely different. In short words, they have differences from the European Union. Some things are similar, but still they have this more power for intelligence services to intervene in privacy to obtain data from service providers, for example. And if you have situations when you as a company transfer your data abroad to the United States, to other locations in the world which are not European Union or European Economic Area, then I would say this is the case to consult with lawyers, because this is the most complicated topic of the GDPR, I would say. There are options when you can transfer data legally. These are completely fine. But for new companies, this typically is a complicated topic, because there are tools in the GDPR which allow you to transfer data. These can be contractual clauses, this can be exemptions or consent of data subject, but this consent and all these other tools need to meet certain criteria. Yeah, this is the short answer.
There just came a quick question regarding license plates when you were talking about the NFTs. Salman came up with it. Are car license plates private, or are they considered public property? Basically, can you collect them and post them on the internet, or that shouldn't be done on a specific site in this case?
Kind of grayish area, because if you take just a car plate and publish it without any link to individual, then you can't determine the private information. But of course, if you have access to this public database, not public, but this state database, then you can determine the owner. And therefore, as a good practice, it is considered to blur the public, those driving plates. Also, Google does it because the regulator on the EU level said, please do all things possible to reduce risks to privacy. And this is one of the tools how to do it. And also in some news publications online in Delphi and TVNet, you can see that also if there is no direct need to publish this license plate, then they typically blur it. Because if if there is an article that, hey, there is this politician drunk driving this car during working hours, then this is one situation. But if these are random cars on the street and no need to discover and publish those numbers, then you can just blur them.
Perfect. Thank you. Thank you so much. I see there is another question. I'm going to add myself to the screen so that I'm not speaking from the backstage, so to say. I see there's another question for Katrin. Let's make it the last question because we only have 7 minutes left over. Does company address transfer within EU really works in Latvia? Could you please share your experience, knowledge?
This is an interesting question. Not sure that I already kind of understand it the way it's supposed to be understood, but if you are thinking about a company which is established in Latvia, has a legal address here, and you are willing to keep the company here in Latvia, just change the legal address in another country and in EU, is that what you're going for?
Vlad, maybe you can confirm or deny.
Okay.
I guess let's assume so.
Okay, so I would not be 100% sure to say that this is the only answer, because this is something new. Maybe I'm not fully aware of all the possibilities. But as far as I know, you cannot just, under Latvian jurisdiction, you cannot just change the legal address to somewhere in a different country in the European Union, due to the fact that you must, if you have a company, you must be reachable in your legal address. So, for example, if State Revenue Service employees know, but inspectors would decide to come and look, how are you working and what's happening, and do you really have a place of business, they would go to your legal address. That's the whole point of having a legal address. So just to change a legal address and specify that it's, for example, an address in Germany, that would be a no-go. if you would like to, if you would like to proceed with your activities in a different country, then there's a possibility you could become an agent, you can establish a branch, you could just open a different kind of business, become a shareholder of your own business. So there are multiple possibilities, but just to change your address to a different European Union country, if I understand the question correctly, would not be a safe option. But yeah.
Okay, thank you so much. Let's hope that was the way the question was asked. And yeah, we are pretty much out of time, and this was a bit lengthier session once again, but then again, the topic is not an easy one, and this was just scratching the surface, I guess. And a huge thanks to Katrin and Yuli for doing a good job at it, and then keeping it understandable. So yeah, definitely a huge thanks to Katrin and Yuli for being here tonight and giving us these talks. And of course, as per usual, you will be able to see the recording of the session and receive the slides as well. I will share all these details tomorrow in the resources channel. Of course, there is going to be a test as per usual as well. That's going to come on Wednesday at some point. One thing I do want to mention that next week we are going to be talking about gaining traction. And just like last week, I asked you to, or prior to this session, I asked you to send in already some questions if you have those. And which you did. Thank you to those who sent them in. If you have any questions regarding gaining traction, once more, just direct message me and on Slack or send an email, and I will forward them to our lecturer. So yeah, thanks for that. And one more thing, next week, it's going to be the final session, by the way. Sorry, this is coming to an end. And after the final session, we are going to have the pitch workshop. I will share sort of a sign-up sheet where you will have to write down if you are participating in the pitch workshop. It might have a limited capacity as well, depending on how many of you participate. Probably no more than 20 teams will be able to pitch. But I will share all this information this week on Slack. So yeah, keep your eyes out for the announcements channel. Once more, thanks to Katrin and Yuli. Thanks to everyone who joined here live. Thanks to everyone who's going to be watching this session as a recording. And yeah, have a great evening and see you next Monday. Bye.
Thanks.
Thank you.
Bye.
Bye.
Thank you.